expectation we'll get this started, but we definitely do want to post it on our website. So we'll make sure it gets takes off with a recording.
Oh, I see something started by Anna Matlock. Has she started it possibly?
I started recording. I don't know.
Thank you. We're good then.
Thank you.
Okay. Good morning, members and members of the public and council members. My name's Roxana Gamusio. I am the Executive Director with the Private Probation Service Council. Today is Friday, August the 11th. We are starting our meeting right on time at 10 o'clock. And the first order of business I would like to do is a roll call vote to make sure that we have quorum, and then we will get started with the items on our agenda. For our members that are on the council, thank you again for being here with us, for your time, and if you could unmute yourself as we motion and definitely make sure that everyone's on board, then we could start. Judge Brody Kane, this is for roll call vote, please.
Aye, here present.
Thank you, sir. Judge Teresa Nelson.
Present.
Thank you, ma'am. Judge Joel Perry.
I'm here.
Thank you. Judge Jason Hudson.
I'm here as well.
Thank you. Michael Wright.
I'm here.
Thank you. And Stacy Kelly.
I'm present.
Thank you. We have everyone on the council is present with us. We have, as the members know, the meeting is always open to the public, and we have an opportunity for them to provide comments as they relate to the agenda. This opportunity has been added on the agenda under our last minute items, which are the new business. And so I'll make sure at the end to check if any members of the public have joined us. Or there are any written comments to make sure to give them an opportunity to participate at the meeting. Notice of this meeting was properly put on the board's website and has been there since the November 4th, 2022 approval of these dates. Additionally, this month's agenda was posted to the website since Friday, August the 4th. The first item of business I'd like to do is to turn it over to our attorney, Michael Underhill, so he can read our statement of necessity. Michael, I will mute myself.
Okay, good morning. This is the regularly scheduled meeting of the Tennessee Private Probation Services Council. Because there is not a physical quorum present, a statement of necessity will be read into the record and filed with the Secretary of State's office. Pursuant to Tennessee Code Annotated Section 8-44-108, if a physical quorum is not present at the location of the meeting of a governing body, in order for a quorum of members to participate by electronic means, the governing body must make a determination that a necessity exists. Furthermore, Tennessee Code Annotated Section 8-44-108, subsection A, subsection 3, defines necessity as a matter to be considered by the governing body at that meeting, requiring timely action by the body. The physical presence of a quorum of the members is not practical in the period of time required action, and that participation of a quorum of the members by electronic or other means of communication is necessary. This is the regularly scheduled meeting of the Tennessee Private Probation Services Council, and the necessity of this meeting with members attending by teleconference means is to conduct timely matters of the council that must be discussed and decided prior to the next meeting. All votes will be conducted by roll call, and that completes the statement of necessity.
Thank you, Michael. Members, we will need a motion and a second to accept this statement of necessity.
Judge Kane, I move we accept it.
Thank you, Judge Kane. Do we have a second?
I'll second it.
Thank you. A second by Judge Perry. By roll call vote to accept, Judge Kane.
Aye.
Judge Nelson.
Aye.
Judge Perry.
Aye.
Judge Hudson.
Aye.
Michael Wright.
Aye.
Thank you. And Stacy Kelly.
Aye.
Thank you, members. Next, we have accepting, also a motion will be needed to accept the agenda as it was sent. All of the members were sent the agenda as it's been posted on the website. And so if there are any changes, please let me know so we can set that right now before we get started. Otherwise, we would need a motion to accept the agenda and proceed as it's been presented.
I'll move.
Thank you. We have a motion to accept the agenda as presented by Judge Perry. Do we have a second?
I'll
Second.
second it.
Thank you. I've got Judge Kane as a second, by roll call vote. Judge Kane,
Aye.
Judge Nelson,
Aye.
Judge Perry,
Aye.
Judge Hudson,
Aye.
Michael Wright.
Aye.
Thank you. And Stacy Kelly. Thank you
Aye.
very much. Members, then also via email, I sent you the minutes from our May meeting, which was the last meeting that we conducted. I've not received any updates or changes to those minutes, but if you have any or have any questions, please let me know and we can discuss those. If the minutes looked correct as they had been submitted, I would need a motion and a second to proceed and accept those, and then we add those to the council's website.
I'll move that we accept the minutes.
Thank you. That's a motion by Judge Hudson. Do we have a second?
I'll second.
Thank you. A second by Judge Nelson. By roll call vote, Judge Kane,
Aye.
Judge Nelson,
Aye.
Judge Perry,
Aye.
Judge Hudson,
Aye.
Michael Wright.
Aye.
Thank you. And Stacy Kelly.
Aye.
Thank you, members. The next item, and on the presentation, the full presentation that was sent to everyone, you should have this information as well. Happy to discuss. The first item of business is our budget update. So we do have first run of numbers through June 2023, which was when our fiscal year ends. The program has added a surplus of $13,945 to fiscal year 2022-2023. This puts the reserve balance at $605,050. It looks like we will end this fiscal year with a additional amount instead of a deficit, which is of course a welcome piece. And if you have any questions, happy to entertain. Otherwise, this number is informational in nature, but I welcome any calls if we have them, or questions, pardon me. Okay. Seeing none, the next order of business is the information that I also sent our members, and I'm happy to send these back to you. If you don't have them, please let me know. These are our 2024 meeting dates, and the information, if the members approve, will be posted to our website to set the 4 meetings that by statute we are expected to hold. The meeting dates are set at still Fridays at 10 a.m. Friday, February the 2nd, May the 3rd, August 9th, and November 8th. If we want to discuss anything else regarding these dates, I welcome. This would be our opportunity. Otherwise, we would need a motion to proceed with these dates.
I would move that we accept the dates.
Thank you, Judge
I'll
Kane,
second.
and thank you, Judge Nelson. We have a motion and a second to accept the 2024 dates as presented by roll call vote. Judge Kane?
Yes, aye.
Thank you, Judge Nelson.
Aye.
Judge Perry?
Aye.
Judge Hudson?
Aye.
Michael Wright?
Aye.
And Stacy Kelly.
Aye.
Thank you very much. I will go ahead then and turn this over to our attorney, Michael Underhill. It is all yours, Michael.
Thank you, Roxana. On the legal report, there is one matter for the council's consideration and vote, and I will go ahead and read the summary and the recommendation into the record. The summary is as follows. This May 22nd, 2023 administrative complaint alleges the respondent has not provided a completed bond form as designed by the Tennessee Comptroller's Office. Everything has been filled out except it lacks a signature of the county executive or the mayor, as the bond form indicates, and that is pursuant to regulation and Tennessee statute. The respondent has attempted to get signatures of both individuals, but due to personal conflicts, the respondent was unable to procure the needed signatures for the bond form. Essentially, this respondent is running for mayor in that local area against the mayor that he needs the signature from. He tried to get the signature from the county executive, but the county executive was of the opinion that the mayor only was the one that needed to sign the form. The respondent has stated that he intended to seek temporary injunctive relief through the local chancery court and has provided me with a copy of the initial filing. I have not received a temporary injunction order yet. That could come at any time, but regardless of that, the recommendation is going to proceed either way as follows. Authorize a formal hearing for license suspension until the required county executive or mayor signature on the bond form can be obtained. And then our settlement portion is to authorize settlement by consent order for the voluntary suspension of the license until the required county executive or mayor signature on the bond form can be obtained. What that will look like procedurally is once this meeting breaks, I will be sending out a consent order giving the respondent 30 days to voluntarily suspend their own license. At the end of that 30-day period, I will then file and serve on the respondent a notice of hearing and charges, and we will have an administrative law judge assigned to the case, and I will set the hearing date, if it goes that far, for the council's next meeting, I believe on November the 3rd of this year. So that's how we will move forward with this recommendation. So with that being said, I will step aside and let the council have their consideration and vote.
Folks, I'll be honest, my call dropped, so I missed that discussion. So I don't know. I hate for you to rehash everything, but I missed. You're about 2/3 of the way through the summary, and I dropped.
No, that's fine. Basically, what we have is an administrative complaint that was filed where a respondent, there's a bond form that the Tennessee Comptroller puts out that we have to have filled out entirely. This particular respondent had the bond form filled out with the exception of having the county executive or the city mayor sign the form. There's a personal conflict going on with the city mayor because this individual is running against the city mayor and could not get that signature. He tried to get it from the county executive, but the county executive was of the opinion that the city mayor is the one that needs to sign the form. And so here we are. The respondent is trying to seek some injunctive relief and has filed an action for that. I have not received a temporary injunction order, so irrespective of that, I'm going to recommend that we authorize a formal hearing to be conducted by an administrative law judge the next time this council meets, but also provide the settlement option of sending the respondent a consent form to voluntarily suspend their own license until they can get one or the other's signature on that bond form, because obviously that would do away with the need to move further to a hearing. And so that's essentially the summary and the recommendation that I have to the council.
Michael, I have a question. Do
Sure.
you anticipate that the 30-day time limit will give the company an opportunity to get the injunction that they're seeking?
It was my understanding, I spoke to the respondent yesterday, and that the judge was going to review the action and try to sign or not sign yesterday. I did not receive anything. A hearing date has been set in Chancery Court for October the 30th, which will occur after the mayoral race. For all I know, he could maybe send it to me after we break from this meeting. But nonetheless, I want to move forward so that we're not time strapped when November 3rd rolls around.
Okay, thank you.
Well, are we punishing somebody because he has a conflict with his political opponent?
That is my understanding, yes. But the bond form has to be filled out. We cannot let him to stay in operation without a completed bond form.
I didn't understand what you said about an ALJ.
Administrative law judge. It's my understanding that this council operates with an administrative law judge as the procedural and evidentiary gatekeeper, and then obviously the council members come up with the ruling essentially.
So we would have a hearing next time, is assuming this doesn't work itself out. There would
Correct.
be a hearing next time, and an administrative law judge would be in our meeting, and he would run the.
Yes.
Okay. Okay.
But again, I mean, I know the company can't operate without the bond form. What we're doing is ensuring that we have a mechanism by which we can enforce it if he's not able to obtain the signature or get the injunctive relief.
That is correct.
But he would not be suspended currently. Until our hearing, he would not be suspended, or she?
Well, if they turn in the consent order, then obviously they would voluntarily suspend their own license. But yes, they would remain in operation. It's not a perfect scenario, but
yeah.
Yes, they would remain in operation until the next meeting.
Is there not an alternative to having the mayor sign it? Can he not get a bond some other way?
Roxana, feel free to jump in on this, but is my
Sure.
understanding no, because the comptroller, or I presume their legal department, was the one that compiled this form, and that's what it requires.
Yes, and I'll just add very little to that, but we had every single one of our license companies make sure to fill out the bond form in its entirety. It's a very it's an older form is all I will say. So it has very specific lines for the clerk, the judge that's giving their clients, if you will, to this private company. And among them are the options, as Michael stated, it is the administrator or the mayor itself. And in this case, neither one has signed it. So the company's been attempting to get these signatures for a while, but all of our other companies obviously have this bond now in their license file. And I don't believe there can be a change. We asked if anything else could be done with the bond, but the answer was no, it has to be filled out in its entirety.
Well, I kind of agree with Joel Perry. I doesn't seem fair to me, but I guess if we authorize your recommendation, he's in no worse shape until the next meeting. I can't imagine he would voluntarily suspend it. It doesn't sound like he's done anything wrong. Personally.
And I agree. I mean, the purpose of the hearing in November would be to kind of force the hand, and I'm sure he understands, or whoever, that if he doesn't do the voluntary surrender, then he remains in operation, and then this problem, in theory, resolves itself by the time we come back in November.
If he does the voluntary surrender and he ultimately gets the signature from the county executive or the mayor, can he be reinstated after that or what's the process for that if he were to do that?
That's the way we've constructed this, that once a signature is obtained, then he is in compliance.
Okay.
But I guess one thing to consider, if he loses the mayor race and the mayor continues to refuse to sign his bond form, does that mean he doesn't get to operate private probation any longer?
I don't want to be the ultimate ruler on that decision, but I would presume that would be a potential ruling.
Can the ALJ not order either the mayor to sign it or some other way get the bond in place? Sounds like, and I don't know the personalities involved, but it sounds like this mayor's trying to put the guy out of business.
I would have to research that, but I don't think an administrative law judge possesses that type of special remedy. which is why he is going into Chancery Court to try to seek that remedy.
Well, I guess as far as the issue before us, I think this recommendation, it sounds like we're kind of hamstrung a little bit about the law, but it sounds like this is a fair recommendation. This is as much as we could do. You know, if we approve this recommendation, it doesn't resolve itself. We come back in November and we have this hearing. Would we have the authority to hold our decision under advisement to grant some additional time, or would we be obligated to make a decision at the time of the hearing?
I would probably have to leave that up to the administrative law judge. I'm just thinking out loud here. I may put something in my notice of hearing and charges that might move past temporary suspension and give the council the option to revoke that license, which would allow him to reapply. In theory, I don't know if that necessarily helps him, but that's where we are.
Well, clearly he cannot operate without a bond. Hopefully he'll prevail in Chancery Court. I guess that's why we still have Chancery Courts in Tennessee.
Well, I guess I'm in the position of being in favor of this recommendation as things currently sit. I would move we accept the recommendation, and then hopefully when we get to the November meeting, this has been resolved by our Chancery Court.
I will second that.
Thank you. We've got a motion by Judge Kane to accept legal counsel's recommendation as presented, and a second by Judge Perry. By roll call vote to proceed with this, Judge Kane,
Aye.
Judge Nelson,
Aye.
Judge Perry, Judge Hudson,
Aye.
Michael Wright,
Aye.
and Stacy Kelly.
Aye.
Thank you, members. Michael and I, of course, have gone over this repeatedly, so I appreciate the conversation. I think all these were very well valid made points. So that concludes the legal report. Still with you, Michael. I'll turn it over to you for the next item, which is the sunshine presentation.
Okay, moving right along. This is a mandatory presentation that has to be given once a year because, as the council knows, there is yearly turnover of its members. And so with that being said, this presentation does have to be given. I know the council members are well aware of the Open Records Act and the Public Meetings Act, but nonetheless, we'll try to run through this content as quickly as possible. I do want to thank Attorney Anna Matlock in my office, who will be doing the PowerPoint portion of this presentation. Thank you, Ms. Matlock. Again, this is regarding the Open Records Act and the Public Meetings Act. There is a disclaimer. I'm not going to read that all into the record here, but basically this is for general and educational guidance and is not to be construed as legal advice. Next slide, please. The Open Records Act, I will talk about briefly. Obviously, that starts at Tennessee Code Annotated Section 10-7-503 at SEC. And what is included in an open records for a board or commission? Obviously, on the left side, we have what it includes. And then on the right side, what it does not include. What it includes is documents, media, electronic data processing, files and output, other materials regardless of the physical form or characteristic. And the point that needs to be made here, as long as it's made or received pursuant to law or ordinance or in connection with the transaction of official business by any governmental entity, then it is subject to the Open Records Act. What it does not include, to the right side of the slide, is devices or equipment where the records are displayed. And so that is briefly what we will need to talk about for the Open Records Act. For the Public Meetings Act, that starts at Tennessee Code Annotated Section 8-44-101 at SAC. And what we're going to be talking about as a general overview is we're going to be putting the information into 4 different buckets here. Number 1, what is the Public Meetings Act? And then what is a meeting and what is not? What is required for a meeting covered by the Public Records or Public Meetings Act regarding the notice, the agenda, public presence, and the minutes, which is essentially what we're meeting for today. And then the board, if the board violates the Public Meetings Act, what is the outcome of that violation, which would be nullity? Moving right along, what is the definition of the Public Meetings Act? It is stated by statute, the General Assembly hereby declares it to be the policy of this state that the formation of public policy and decisions is public business and shall not be conducted in secret. Furthermore, this part shall not be construed to limit any of the rights and privileges contained in Article 1, Section 19 of the Tennessee Constitution. The Public Meetings Act is remedial in nature. It is fluid, and it should therefore be construed broadly to promote openness and accountability in government and to protect the public against closed-door meetings at every stage of a government body's deliberation. The application: all meetings of any governing body are declared to be public meetings open to the public at all times, except as provided by the Constitution of Tennessee. The governing body, that means the members of any public body which consists of 2 or more members with the authority to make decisions for or recommendations to a public body on policy or administration. And the Public Meeting Act obviously applies to all boards and commissions of which this council belongs. The Public Meeting Act applies to every meeting of a board or commission. So let's define what public meeting is. The meeting is the convening of a governing body of a public body for which a quorum is required in order to make a decision or to deliberate towards a decision on any matter. And that also includes committee and subcommittee meetings. What is not a meeting? A meeting does not include any on-site inspection of any project or program. So the inspectors cannot, in conjunction with the inspection, deliberate towards a decision. They just report their findings, and then we present that to the board accordingly. Again, what is not a meeting? A meeting does not include a chance meeting of 2 or more members of a public body. However, no such chance meeting or informal assemblages can be used to decide or deliberate public business in circumvention of the spirit or requirements of the Public Meetings Act. And then on the right side of that slide are some examples of same. What is not a meeting? There's a Tennessee Attorney General opinion that states 2 or more public members of a public body may share a meal together in which public business is not conducted. So a discussion should not constitute deliberations, for example, examining and consulting in order to form an opinion, weighing arguments for and against a proposed course of action. What is not a meeting? Lunch breaks, restroom breaks, smoke breaks, recesses between morning and afternoon sessions, and adjournments between days of a multi-day meeting. These are all times when board business should not be discussed, which I know this council is fully aware of. Regular meetings and special meetings count as meetings and all are subject to the Public Meetings Act, with the exception being executive sessions and or human resource type matters. Now, when we have an executive session or a human resource type matter, that is obviously where the board will meet outside of the public, and they will essentially, if it's an executive session involving maybe current litigation or some possible future litigation, that's where an attorney will come in and brief the members of the council on that litigation or potential litigation, same as with a human resource type of executive decision or executive session, where somebody from HR will come in and brief the members accordingly. In my time with the with my board and with my council, I've never seen a board or council break out an executive session regarding a human resource matter, but it can happen. Rarely, but it can happen. So next slide, please. Now, with regard to executive session, the board may not deliberate about any specific matter before it or potentially before it in any executive session. Mainly those sessions are information only type sessions where somebody comes in and basically lets the board know what's going on. Now, how far does the executive session go? There's a Tennessee Attorney General opinion that says oral interviews conducted by the Civil Service Commission of Maury County with persons applying for jobs within the classified service of the Maury County Sheriff's Department do come within the provisions of the Open Meetings Act. And that could be where, I guess to bring it closer to home for our council, say if there's a human resource type matter involving an executive director, obviously we already have Roxana, but if someone was to be hired, that might be something that could be discussed in a executive session, but where there's no action to be involved, it's just basically for information only. Next slide. If a member were to, let's talk about electronic communication. If a member were to email the chair, hey, here's a news article, I'd like to include this on the next agenda, that would be permissible. However, what is not permissible is, here's a news item about one of our licensees, we should consider revoking this person's license. Obviously, that is something that needs to be done in an open meeting, not something that should be done, through a email among members. If a member were to email the commission's counsel, hey, I have a question about the legal consequences of something the commission has done, that is something that is permissible. However, what is not permissible is I have taken an action as a commissioner and now someone is upset. So we'll leave all action for the public meeting. If a member emails another commissioner, if you send an email or pick up the phone to call another commissioner, that is not what we would consider to be a chance meeting. Even if you don't discuss commission business, it gives a strong appearance of impropriety, and for safety's sake, it should be avoided. I think what's good about this council is obviously we're spread out among the 3 grand divisions, but there's always that appearance of impropriety. I'm not saying that can't happen, but if it does happen, it needs to be strictly personal and not about council business, as this council obviously knows. What if let's talk about attendance. What if one or more of the members cannot attend a meeting in person, as we have in this instance? The absent member may participate telephonically. Obviously, we don't have that going on today, but all votes must be by roll call vote, and that is so the public may know how many commissioners voted on each issue. Now, also with electronic attendance, what if one or more of the members cannot attend a meeting in person? Tennessee Code Annotated Section 8-44-108, subsection B1 and subsection 2. If those members present in person make a quorum, then the meeting may proceed as normal, with the other members participating by phone or electronic means of communication. However, that telephonic member will not count against quorum. They can do a roll call vote, but they do not count against quorum, since quorum requires more of an in-person presence. State versus Shelby County Board of Commissioners, the Public Meetings Act is to be construed most favorably to the public. Public policy favors open meetings and is all encompassing and applies to every meeting of a governing body, except where the statute on its face excludes its application. Furthermore, with regard to the Public Meetings Act application, the public has the right to attend and observe the meetings, but not the right to participate. However, as we will do later on in this meeting, the department permits public comment so long as the comment is not disruptive to the flow of the meeting. And there are some examples of same. With regard to public comment, it is not a question and answer period. It is not to concern itself with matters like disciplinary matters before the council. It is strictly if they have a public comment, they can make that public comment and then leave it at that. Now, let's talk about adequate public notice, which obviously we have to have pursuant to the Sunshine Law and the Open Meetings Act. There's a three-pronged test for adequate public notice. Prong 1, the contents of notice must reasonably describe the purpose of the meeting or the proposed action to be taken. Prong 2, the notice must be posted at a time sufficiently in advance of the actual meeting in order to give citizens both an opportunity to become aware of and to attend the meeting. And then prong 3, the notice must be posted in a location where a member of the community could become aware of such notice. Usual methods are obviously the internet, posting in a newspaper, or bill posting. Obviously, our usual practice is to post it on the website of the department and obviously the Private Probation Services Council website where the public can receive notice. Next slide, please. With regard to the three-pronged test for adequate public notice, whether public notice is adequate is in all the facts and circumstances analysis, and no single factor is dispositive. Moving on, what is the legal effect if the Sunshine Act is violated? That would be nullity. And in a nutshell, the Public Meetings Act is designed to make sure that all board business is conducted in a way accessible to the public. It applies to you both as an individual member and collectively as a board. All gatherings of more than one member are meetings and covered by the Public Meetings Act, including regular, special, and emergency meetings, and including committee and subcommittee meetings, as we stated before. Again, as we stated before, the only exception is the executive session, which is your opportunity to ask your board attorney questions, but you may not deliberate or decide. And for every meeting, you must give adequate public notice relating to content, location, and time. If you violate the law, any violative action or act is void, and the cost of litigation resulting from an action may be assessed against the board. Now, there is one case that I'm required to talk about, an outside Tennessee case, North Carolina Board of Dental Examiners versus the FTC. And the background of that case, the North Carolina State Board of Dental Examiners, or the board, issued 47 cease and desist orders to non-dentists about teeth whitening. And in response, the Federal Trade Commission filed a complaint alleging that the board violated antitrust laws by unilaterally ordering non-dentists to stop providing whitening services. The board argued that they had immunity through state action, and the Federal Trade Commission ultimately prevailed at the U.S. Supreme Court level in its action. The United States Supreme Court rejected the board's state action immunity defense because the board did not receive active supervision by the state. And we will talk about that here in a minute. When it interpreted the act by addressing teeth whitening, and when it enforced that policy, issuing cease and desist letters to non-dentist teeth whiteners. It went on to further state, state agencies are not simply by their governmental character sovereign actors for purposes of state action immunity. Immunity for state agencies therefore requires more than a mere facade of state involvement, for it is necessary in light of Parker's rationale to ensure the states accept political accountability for anti-competitive conduct they permit and control. So what is active state supervision? The inquiry regarding active supervision is flexible and context dependent. Active supervision need not entail day-to-day involvement in an agency's operations or micromanagement of its every decision. Rather, the question is whether the state's review mechanisms provide realistic assurance that a non-sovereign actor's anti-competitive conduct promotes state policy, rather than merely the party's individual interests. Through the enactment of Tennessee Code Annotated Section 4-4-1265 in 2021, this established supervising officials. So who is a supervising official? With regard to this particular council, we have a commissioner or a chief executive officer of the administrative department under which the regulatory board operates or to which the board is administratively attached, or the commissioner or the officer's designee. In this instance, I would submit that that would be our executive director, Roxana Gamusio. And the role of that supervising official or executive director in this circumstance is each supervising official shall ensure that the actions of the regulatory board or boards that displace competition are consistent with a clearly articulated state policy. Other than rulemaking, the supervising official shall evaluate whether the action may constitute, an action of the board may constitute a potentially unreasonable restraint of trade that would require further review. And if that further review is required, if it is determined that that action is required, notice will be provided to the board within 10 business days that the action is subject to further review of the full evidentiary record regarding the action, and if necessary, supplement the evidentiary record or direct the regulatory board or other involved persons or entities to supplement that evidentiary record. Conduct a review of the substance of the action de novo and on the merits, and then in writing either approve that action, remand that action, or veto that action. Now, that concludes the Open Records and Open Meetings Act presentation. If there are any questions, I would submit to the council members. They can either email me and or Roxana with that question, and we can provide an answer through that means. And if obviously any further research needs to be conducted, we can again provide that through that means. So thank you.
Thank you, Michael. Thank you so much for getting this done for us. Members, we are on our last item. This is new business. Anything that the council would like to discuss is open. At this point, I also want to take a minute to make sure that any members of the public that are participating with us remotely through Teams. If they have any comments that they'd like to add regarding the agenda items or any questions, this would be the time to entertain those. Dana, I don't see any hands raised or anything. Do you or
No, I don't see any.
thank you. We are in compliance with that. Any questions or comments, members? Otherwise, happy to entertain a motion to adjourn and give you back the rest of your Friday.
I'll make the motion.
Thank you, Judge Perry. We have a motion to go ahead and adjourn, and I've got us at 10:46. Do we have a second?
I'll second it.
Thank you, Judge Hudson. I think we are good with a motion and a second, not needing to do roll call vote for our last item, which is to adjourn. Thank you, everyone that has been on the meeting for participating and those that joined us. Michael, anything that I've missed that you want us to address before we end our meeting?
I do not see anything further.
Thank you, sir. Thank you very much. Dana, we can go ahead and stop the recording. Thank you to everyone and look forward to connecting again at our November meeting.
Thank you. Y'all have a good week.
You too. Bye-bye.
Thank you.
Thank you, Bella.
Bye-bye.
Thank you.